there are some other issues. There is a recent press release of the People's Action Movement seeking to say, whether in terms of politics or law, that it really doesn't matter what the court said on the basis of the contempt, but that the injunctions served their purpose. Well, I am not sure what that means, because if I remember correctly, the People's Action Movement lost the elections on the old boundaries. And one of the things that we needed to emphasize was that the government's desire to look at, review, and alter and modify the boundaries as part of the reform was that it had its genesis in the Commonwealth Report of 2004, which in effect said that elections in St. Vincent and St. Kitts, could not and would not be fair because the concentration of electoral power was of close to 68%, rested in the Bastille suburb, which were essentially politically controlled by the St. Kitts Nevis Labour Party. So I do not understand how you can celebrate an injunction when in fact you lost the election and the position of the Honorable Prime Minister was new boundaries or no new boundaries, the St. Kitts and Nevis Labour Party was going to win the general election. So instead of taking wind away from what is a significant win for Dr. Dennis Merchant and the government of St. Kitts and Nevis, this rather pitiful cry about the injunction served their purpose when you lost the election is something that we on the legal team have some difficulty on understanding. The other issue is that there was an issue on the question of costs that in relation to this matter, and that in previous appeals that we have withdrawn in relation to the boundaries matter and the other matters relating to Dr. Henry Brown, that the court ordered costs against the government. There may have been one or two instances in the past, we tried checking the record, when the matter went to a judge in chambers, when costs may or may not have been issued against the Attorney General. But this was very early in the day. The more recent judgment was delivered by Mr. Justice of Appeal Gordon as well. There were two judgments delivered by the Court of Appeal on Monday. One included the question of costs, where the Attorney General and the Boundaries Commission had in fact withdrawn appeals number 7 and 10 of 2009 because the judgment of Mr. Justice Thomas had made these appeals no longer alive and necessary. And in the judgment of the court delivered on Monday, the 13th of September 2010, Mr. Justice Gordon of Appeal applied the very same ruling that he applied in the Dr. Dennis Merchant case and ordered that there were to be no order as to costs against the Attorney General and the Boundaries Commission. So costs cannot be used as a weapon for political propaganda because neither side was able to get costs from the Court of Appeal. But the significant fact is the complete vindication of Dr. Dennis Merchant and the complete vindication of the government of St. Vincent and of St. Kitts and Nevis. The other matter I wanted to deal with was the issue of another press release by Mr. Eugene Hamilton concerning the question of costs against Dr. Denzel Douglas and Cedric Liebert. You know, I always have to resist the temptation of saying things that sounds partisan and political. It's the human nature to react with anger when you read these sort of things. Let the position be very clear. There was no order of costs issued against Mr. Cedric Liebert. There was an order of costs of $1,000 against Dr. Denzel Douglas. Mr. Terence Byron insisted on costs in the region of $2,500. I suggested, having initially said there should be no others to cost, $500. So if we want to play the mathematical clown, 1,000 is a lot closer to 500 than it is to 2,005. So I suppose I can say we claimed the victory we got. I mean, this is so stupid. I'm just making the point to show you how stupid it is. But the reason why this press conference is also press released by Mr. Hamilton is also misleading is that he does not say in express terms that what was before the Court of Appeal was an application for leave to appeal by Dr. Denzel Douglas and Mr. Cedric Liburn, and that we have, when I say we, that is Mrs. Patricia Dublin-Lewis, Mr. Sylvester Anthony, and myself, after full discussions with Dr. Douglas and Mr. Cedric Liburn, agreed essentially and specifically on the instructions of Dr. Douglas and Mr. Cedric Liburn that they would rather fight the matter before the jury on the facts than have the lawyers prolong these things on a question of law in the Court of Appeal. We agreed, and we were obliged to follow the instructions of Dr. Douglas and Mr. Cedric Liburn, which is forget this appeal, let's go to court, let's fight this thing down. We all know what's happened. We all know what followed the 93 elections. We all are fully aware of the Commission of Inquiry, which made certain findings about the conduct of the last government. Let's go to the... So we had to go. We had to comply with the instructions of our client. So there was no victory for Mr. Eugene Hamilton, my friend. I'm beginning to realize that every time the court turns left or right, the People's Action Movement claims either defeat or victory, as if the court now has become part of the political platform of the People's Action Movement. Ladies and gentlemen, there were one or two other matters I wanted to deal with, but we've had a late start. So we're open to questions now. I will take questions from anyone who wishes to ask questions at this time.
Gus Williams, Radio 1, 94.1 FM. First, let me say to the members of the top table, many congratulations on a very, very interesting legal representation, which probably will go down in the history books as one of the best in the Eastern Caribbean. The question that I would like... One
of the best teams or one of the best judgments?
Both.
I'm just joking. I know what you mean. I'm sorry. Go ahead.
Okay. The question that I would like to put to you, the defamatory statements and character assassination in the broadcast and print media, which we are a part of, and this was information that was fed to us, did it deter or intimidate you from taking the action which led to Monday's Court of Appeal decision? And the second part to that question, would it be reasonable to say that the injunction was brought as a delay tactics, as the PAM was not ready politically to contest the general elections, and it was an elaborate smokescreen that was created for that purpose?
Well, let me answer the second question first. I wish there was a politician here to answer and say yes. But as a legal team, that was the impression that we had. Because every step we took and every time we tried to set the things straight, we were confronted with a legal fight. Even on the question of the law which was passed initially by the Parliament to amend the law on the question of nomination, which this same very legal team, Mr. Anthony, Dr. Kenny Anthony, Mr. Sylvester Anthony, Dr. Henry Brown, myself, and the young lawyer in the Attorney General's chambers who represents the Attorney General, Mr. Arud Gusai, even when we went to the court to say, look, we appreciate that the law has to be changed, it was wrong, and we need to regularize it, it became another major political issue. My instinct is that that was the plan. Injunction after injunction to delay the election. And I suppose with hindsight, the St. Kitts Labour Party will say, thank God for that delay.